One of the key characteristics of the Westminster Model is the absence of strong judicial review, and that makes it all the more interesting that we're standing outside one of the newest political institutions in the UK, that is the Supreme Court. The Supreme Court was created under the Constitutional Reform Act of 2005, and as of 2009 it took over responsibilities that previously rested with the law lords in the House of Lords.
The Supreme Court in the UK isn't a powerful institution like in Germany or a more famous example in the United States. Their Supreme Courts can actually strike down legislation passed by their parliaments. In the UK, the Supreme Court can challenge only what's called secondary legislation, which are additional bits from primary legislation passed by Parliament. It also has an influence over judicial review and via the Human Rights Act. That's not to say, however, that the Supreme Court isn't powerful and influential. It can stop governments acting and doing what they wish. Famously, in the case of MPs' expenses, the Supreme Court ruled to open up details about what MPs were using their additional cost allowance on, and also more recently ruled that the government had limited power to block freedom of information requests relating to notes written by Prince Charles.